We have a couple changes to walk through today. So I'm just going to have Katie walk through the whole bill, everything that's there, not just the changes we made this morning, and then we'll hear from stakeholders.
Good morning, Katie McLennan, Office of Legislative Counsel. And I share my screen so you can see the new language. We're looking at draft 5.3 this morning.
Goodness, one of the bigger numbers.
That's very small.
That's great.
So first we have section 1, which is 7505. And this is the section we've been working with on the warrant. And this is sort of the how, if there's no physician available to do that initial certification, how would you take somebody into temporary custody and transport them to get them that initial examination? So in subsection A, we have language that in emergency circumstances where certification by a licensed physician is not available without serious and unreasonable delay, and when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment, the person presents an immediate risk of serious injury to self or others if not restrained, a law enforcement officer or mental health professional may make an application not accompanied by a physician's certificate to any superior judge for a warrant for an emergency exam. That's all existing law except for the few little strike-throughs. New proposed language: the application shall be based on facts personally observed by the mental health professional or law enforcement officer, or shall be supported by a statement of facts under penalty of perjury by a person who personally observed the facts that form the basis of the application.
Katie, do you envision a statewide form that would be part of that affidavit?
I would say that's a better question for the practitioners in the field. My understanding is there is a form now, and potentially this could change how the form is drafted or written, but the statutory language does not direct the creation of a form or an amendment of a form.
And Alan, I know you're probably far behind on this, so yeah, that's great. And then we can also talk offline too.
Yeah, okay. So right now, that new proposal, if the officer doesn't see it, he's at the scene, and there's really nobody to step up to give any account of it, does he have the right to make a decision?
So this language says that the person applying for the warrant, if the person is the law enforcement officer or the mental health, they have to personally observe it. So if they are not personally observing it, then they don't have another witness who can swear to the facts, then they do not have the ability
So
to.
they hang around until something happens.
I don't know how that would play out.
Yeah, so let's wait until the others come up. This is focused on the language.
Okay. And then we have subsection B, several changes here. So we have language that the law enforcement officer may take the person into temporary custody if the law enforcement officer has probable cause to believe that the person poses a risk of harm to self or others. The law enforcement officer or a mental health professional shall apply to the court for a warrant without delay when the person is in temporary custody. The law enforcement officer or a mental health professional, if clinically appropriate, may transport the person if the law enforcement officer, or a mental health professional conducting the transport has probable cause to believe that the person poses a risk of harm to others, or to self or others. And then we have language that's repeated further down. The transports conducted pursuant to this subsection shall provide individuals with the same protections as provided to individuals in the custody of the Commissioner of Mental Health who are transported in 7511, which is the section 2 of the bill, I believe. And then we don't have changes to subsection C. We do have changes in D. So we have the language, if necessary, the court may order a law enforcement officer to transport a person to a hospital for an evaluation by a licensed physician to determine if the person should be certified for an emergency exam. And then we have that same subdivision again. Transports conducted pursuant to the subsection shall provide individuals with the same protections as provided as individuals in the commissioner's custody or transported pursuant to 7511. And then we have new language, a new subsection, that authority to transport the person pursuant to the section shall expire if the person is not taken into custody and transported within 72 hours following the warrant's execution. And then we're just renumbering what used to be subsection E to be F. We have some changes with putting license before physician and using gender neutral language. And then that brings us to section 2, the transportation section. The language here is that the commissioner shall, so again, these are people that are in the custody of the commissioner now that we've moved to 7511. These aren't people in temporary custody. These are people who have already gone through that process of commitment.
Commissioner, Department of Mental Health.
Yes. Thank you. The commissioner shall ensure that all reasonable and appropriate measures consistent with public safety are made to transport or escort a person subject to this chapter to and from any inpatient setting under the jurisdiction of the commissioner in any manner that prevents physical and psychological trauma, respects the privacy of the individual, and represents the least restrictive means necessary for the safety of the patient. We don't have any changes in subdivisions, subsections B and C. In subsection D, we do. So it is the policy of the state of Vermont that mechanical restraints are not routinely used on persons subject to this chapter unless circumstances dictate that such methods are necessary. A law enforcement vehicle shall have soft restraints available for use as a soft first option, and mechanical restraints shall not be used as a substitute for soft restraints if the soft restraints are otherwise deemed adequate for safety. And then we have section 3. So this is a report on the warrant process itself. So this directs that by January of this coming year, a DMH in consultation with Vermont Care Partners, Vermont Legal Aid, and persons with lived experience of involuntary admissions procedures shall submit a report to the governor and the healthcare judiciary on upstairs and downstairs, containing any proposed changes to the warrant process in 7505, including mechanisms to reduce safety risks and reduce delays in accessing care.
And I do want to add, for purposes of discussion, that we add in and add freedom to the people who would be part of this group, which is WILDA's organization.
No.
And then we have the effective date of July 1, 2023.
Great. So again, I want to make sure I have this right in my head. We open it up. So the first section, 7505A, talks about how you can begin the warrant process and who can begin it. And that it needs to be personally observed by a law enforcement officer or a mental health professional. And if not, someone signing a statement of fact under penalty of perjury. So that's to say, yeah, we think this person needs to come start the warrant process. And then E is about temporary custody, which is not, for Alan's purpose, it's not temporary custody for criminal activity. It is temporary custody because someone may be in crisis. And what do we do? How do we protect that person or others while this warrant process is working through the process? Do I have that right, Katie?
Yep. And I would say that B also kind of gives us a timeline of how temporary custody fits in with applying for the warrant and how transportation would work.
And then on page 3, E, it talks about the fact that, if the warrant has been executed, that runs out in 72 hours. So right now there's no end to that. So someone may not be taken into temporary custody until the warrant's executed. And let's say the crisis is passed and the person is no longer a harm to themselves or others. But 30 days later, something happens and they see that there's a warrant for that person, I mean, that's, you know, we don't want that to happen. So that's the 72 hours.
Okay, I got, just so help me understand the whole scenario, and I'm talking about Franklin County. The first responders to any emergency of any sort is going to be the ambulance service. What role will they be partaking? It could be an hour before a
So
a law officer shows up. We don't have any coverage in Franklin County, in my area.
right, but what about mental health professionals?
Well,
So-
same thing, St. Albans, which is 20, could be 30 miles away. So ambulance is going to be the first people on the scene. So somewhere they've got to make a decision. They can either talk the person down or bring them to the emergency room. You know, I can see a scenario where this is going to be an issue up in rural area of Franklin
Right.
County.
Would they
So if-
sign the affidavit?
It's probably already an issue, right?
Oh, yeah, oh,
Probably
it
already
is,
is an
yeah.
issue because this is current law. So it probably already is.
But
We
usually the
cannot-
ambulance service takes them. You know, there's 2, 3 people on the ambulance service, they bring them to the emergency room.
Okay, so let's hold that question until we have some of our witnesses come up. We
Okay.
could maybe shed some light on
I'm
that.
just trying to figure out the
Yeah.
whole, yeah, I want to cover everything.
Yep,
Thanks.
yep.
I'm just thinking though that the ambulance would not transport them if they were involuntary.
Well, that's true too.
Because we're-
No, there's a whole.
Right, but
this is
what
I'm
happens,
saying, yeah.
right, what happens in the time,
Yep.
right? I don't know. I don't know what happens today.
Yeah, I'm gonna follow up on what you just ran by Katie here, because I just want to make sure that B follows A in terms of the process. So a law enforcement person is on the scene, does not observe his behavior. You get someone who does to sign an affidavit. If that's what it is, or he observes it, either way. So that's what A spells out. Then B, what confuses me is when it says they may take the person into temporary custody, but temporary custody is what this is about, correct?
So what B is about, yes.
Okay, but isn't the whole thing about temporary custody? Okay.
I mean, the
So
whole
this-
process.
This describes the procedure of the custody, of taking the person in and applying for the warrant. Okay, because it says if the law enforcement officer has probable cause to believe that the person is a risk to himself or others. So that probable cause comes from his own observation or the affidavit. Okay, all right, just want to make sure it builds on,
Yes.
okay.
I think what I'm hearing, and you can correct me if I'm wrong, it's not, A and B are not necessarily set up in chronological order. I think probably because every situation is a little bit
Yeah,
fluid,
sure.
but A is setting up, this is a process, this is an option. You have this warrant option.
Yeah.
If other options are not available. So it's sort of setting up what the warrant is, how you use the warrant, how you apply for the warrant. And then B is more giving you a timeline of how temporary custody works, how it works with the warrant, how it works with transportation.
I just want to make sure B wasn't some standalone piece of this.
The whole section really should be read together.
Right, okay,
Yeah.
okay, so you got the warrant piece, you got this piece, the temporary custody, and then we've got the transportation stuff. Kinda, okay.
All right, any other questions on the language?
This is a funny question. I've never seen the governor mentioned anywhere in a report.
It does, yes. It's not frequent, but it does happen.
So that's interesting. Why here?
Because that's what I was asked to draft.
Why here?
That's Department of Health when they come in.
Okay.
This is their language. Great, thank you, Katie. Appreciate it. So, should go first. Hilda, do you want to go since the changes to B were partly yours, or they were, Dylan started it and then you provided additional language, so I think that would be great. Actually,
I got the whole bill.
Thank you. My name is Wilbur White. I'm the founder of an organization called Mad Freedom, which is an organization whose mission is to secure the kind of rights of people who are perceived to have a mental illness. As you know, Mad Freedom did not support this bill at the outset. We had concerns about its constitutionality and then the risk that it would impose on law enforcement officers, because they could be sued and their municipalities could be, out of money for paying law settlements. We, in the course of working with the kind of stakeholders, we have come up with some language that addresses Mad Freedom's concerns about the constitutionality of the provision. And so we support the changes to both subsection A and subsection B. And we support the report as long as Mad Freedom is included in the stakeholders who would be consulted. I might ask that you change the language around the report where you say, I'm now on the last page. No, actually it's page 5 of 6, line 5, where you talk about the report. And you say that people to be consulted are, quote, persons with lived experience of involuntary admission procedures pursuant to 18 VSA Chapter 175. I talked to, Mad Freedom's constituents, the people who have been subject to this section. Not a single person knows that they were subject to 18 VSA Chapter 179. They're not told. So I would suggest that you include some language that maybe just say persons with lived experience of involuntary admissions is not exactly appropriate either, because that could be somebody who wasn't subject of a warrant. So the people who are really have knowledge about this are the people who've been picked up by law enforcement officers and taken into temporary custody. So if the language could reflect that class of people, I think it would be, I think that would be great. And then finally, I think that on page 3, subsection E, or subdivision E on line 6, you write that authority to transport a person pursuant to this section shall expire if the person is not taken into custody and transported within 72 hours following a warrant's execution. So I think there's some problems with this language, because what I understand legal aid suggesting was that a warrant will expire 72 hours after it is issued, meaning signed and dated and time-stamped by a judge. A warrant is executed by taking the person into custody. So this language doesn't make sense the way it's written, because it wouldn't expire 72 hours after the warrant's execution, because it's executed by arresting somebody. So I think you just want to say the warrant expires 72 hours after it is issued or signed and dated by the judge. Other than that, I appreciate the hard work that went into coming up with and building consensus around this. Mad Freedom does believe the warrant statute needs to be revisited, and we're very pleased that there's going to be a process for doing that. So thank you.
Any questions?
I do have a response to your question, if I may. Sure. So EMS have their own protocol. It's written about what they do when they encounter a person in the field who they believe poses a risk of harm to themselves. And they typically follow that protocol. So they're not really implicated by this statute, but there is a process for them.
Oh, yeah, I'm sure there is.
Yeah.
But I just know that by the time they get a warrant or a law officer shows up, sometimes at home it's a long time.
Yeah, they don't need a warrant.
Right.
You got to apply for it.
No, they don't actually. EMS don't have to apply for
So
it.
they have a different process.
They have a different process.
So
Completely.
if AMS, I think what we'll be saying is if EMS shows up, this wouldn't even apply.
It doesn't apply to them. Yeah, they have a protocol. Yeah.
When we have them in next year again, because we'll be taking EMS up again, it'll be interesting to understand what that process is. Susie?
Wilda, thank you so much for all of your time and coming down here to help us get this into something that makes sense for people and I just really appreciate your expertise and willingness to be patient with us, and thank you so much.
Well, thank you. I appreciate your working with us, and look forward to the report, actually.
We do too. Thanks, Wilda.
Thank you.
Jack or Lauren, are you both testifying or one?
I'll be testifying.
Okay, great. Welcome.
Thank you. Good morning, Madam Chair, members of the committee. I'm Jack McCullough, the Director of the Mental Health Law Project of Vermont Legal Aid. I want to express my appreciation for all the work that the committee has done on this, especially at this time in the session when I know everybody is scrambling to get your work done. I appreciate the comments we heard from Wilda White. I agree with her that we could change the word executed in that provision to issued, and it would be a good change. And beyond that, I think we're good to go with the bill as you have it.
Great. Thank you, Jack. Any questions for Jack? Okay, so we'll let Katie make a change to what she thinks is best, and we'll run it by everyone again, maybe before we even leave today. Great, Jack, thank you. Any questions for Jack before we go to Dylan? Great, thank you.
Thank you.
Dylan, you want to come up?
Hi, Dylan Burns, Mental Health Services Director at Vermont Care Partners. I think my comments are really going to echo what you've heard. Really support the committee's hard work on this, especially you, Chair Houghton, in the last couple of days wrangling us. And from the beginning, our hope had been to really have more clarity in the warrant statute so that there wasn't kind of finger pointing in the field that was going to delay care. And this last set of revisions retains those pieces that really make clear that just law enforcement is taking someone into temporary custody, and also make clear that a judge can order, we didn't focus on it today, but instead of saying a judge can order a law enforcement or mental health professional to transport a person, it says a judge can order a law enforcement officer, and elsewhere it says that a QMHP, a mental health professional, would transport if clinically appropriate. So those were priorities for the emergency services teams that I work on behalf of. I think we've talked through most of the other changes in here. I will say, as you all know, I facilitated a stakeholder process over the summer, and I'm not necessarily suggesting changes. I am not suggesting changes to the current language, but there are all sorts of folks who contributed to that: judiciary, parents and families, who I think are interested in this topic, and I would hope and assume the department would seek input from them as well, but I'm not saying to write it in at this point.
Okay. Do you feel comfortable changing persons with lived experience to something other than for the of involuntary admissions? And I should have asked Jack that question as well. So whatever we might, in persons with lived experience, I'm going to look to Katie for some language suggestions there. But that kind of opens it up to more people than just, not the whole group that you just mentioned, but.
Okay. That makes sense to me.
Okay. And Jack, are you okay with that? Okay, great.
Thanks.
Thank you, Dylan. Oh, wait, hold on.
Oh, yeah.
And Dylan, I don't know if you're the person to ask this of. When a warrant is applied for, law enforcement, okay, let's see, shall apply to the court for the warrant without delay. So in the real world, I'm in the field, you have the individual. Phone call gets that done? Is that what does it?
It's my understanding that in the field, folks like mental health providers may write out the warrant application, get a judge on the phone and read it to the judge, and then finalize the process later by going to the courthouse, say, getting a signature.
Okay.
But that, if it's 2 a.m., it could be reading it over the phone.
Okay, so it's that type of, that's the actual application in a real world situation. no matter when, and then you follow up later because now you've taken the person, now with this bill, you have the right to transport them,
Correct.
right?
Yep.
Okay, just what I said in my head. Thank you.
Great.
And actually, I did want to say, I do think we've had this longstanding practice of Team 2. You've heard Kristen Chandler, the Team 2 coordinator, testify here. And I think our network really sees the value in that collaborative response, mental health and law enforcement working together in the field and kind of taking different roles in the moment that will help kind of move things forward. So I think this bill reflects that. And I think as we continue to work on the warrant process, really making sure that the way we do that here in Vermont is part of the warrant process language.
Right.
Thanks.
So I think Karen Barber from Department of Mental Health is testifying in judiciary. So I think at this point, we'll take a short, let's say, 10-minute break. Come back at 9:45. I'll check in with Katie on some language changes, and we'll see if Karen Barber can be here about that time. Just to